Good evening and welcome to Courts Today by Live Law. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. The Constitution Bench comprising CJI Chandrachud, Justices Surya Kant, M.M. Sondaresh, J.B. Pardiwala and Manoj Mishra today continued hearing a batch of petitions challenging Section 6A of the Citizenship Act 1955, which was inserted to give effect to the Assam Accord of 1985. The petitioners had concluded their arguments yesterday and today the respondents argued. The court directed the union government to furnish data on the inflow of illegal migrants to Assam and northeastern states after March 25, 1971. It also directed the centre to inform the steps taken by the government at an administrative level to deal with illegal immigration into the northeastern states, particularly Assam. Significantly, during the hearing, the court said that regardless of its position on Section 6A, it proposed to deal with the issue of illegal immigration seriously. Let me tell you, 25th March 1971 is the date of commencement of the Bangladesh Liberation War. According to Section 6A, persons of Indian origin who migrated to Assam from the present-day Bangladesh region between 1st January 1966 to 25th March 1971 are eligible to obtain Indian citizenship. However, persons who migrated to Assam after this date are not eligible to Indian citizenship and are liable to be deported as foreigners. Foreigners' tribunals have been established to determine whether persons are illegal migrants or Indian citizens in reference to this cutoff date. The proceedings in the matter will resume next week. Stay tuned with us. Yesterday, the Supreme Court, while hearing English professor and Bhima-Koregaon accused Shoma Sen's plea against a Bombay High Court order, indicated that it would have to examine whether the supplementary charge sheets filed in the case levelled any fresh allegations against her and were these brought on record before the High Court. The bench of Justices Aniruddha Bose and Augustine George Massey was hearing an SLP filed by Sen challenging the Bombay High Court order, which directed her to approach the special N.I.A. court trying her case for bail. She has been lodged in jail since 2018 for offences under the UAPA after being arrested in connection with the 2018 caste-based violence that broke out at Bhima-Koregaon in Pune, and for having alleged links with the proscribed outfit Communist Party of India, Maoists. The top court had issued notice in Sen's SLP in May this year. Additional Solicitor General K.M. Nataraj questioned the High Court's order remanding the matter to the trial court, arguing that it ought to have considered Sen's application on its merits. Senior advocate Anand Grover, however, protested, arguing that all relevant material had already been placed before the top court for its consideration. He insisted that there were no fresh allegations against Sen in the supplementary charge sheet. He also said that Sen's appeal was squarely covered by the Veron Gonsalves judgment from earlier this year, who was granted bail by the Supreme Court after almost 5 years in custody. The Supreme Court was set to continue hearing the matter today, but due to a change in the composition of the bench, it will be heard now on 10th January. The Punjab and Haryana High Court has quashed an FIR filed against former Chief Minister of Punjab, Charanjit Singh Channi, for violating the Model Code of Conduct during the 2022 state elections. Channi, along with the late singer Sidhu Moosewala, were booked under IPC for campaigning in the Mansa region beyond the prescribed time limit. During the Punjab elections in February last year, the Deputy Commissioner of Mansa passed an order to enforce Section 144 of CRPC and directed that the election campaign shall come to an end after 6 p.m. It was alleged that Channi, along with over 400 persons, and Sidhu Moosewala were reported to be campaigning door-to-door after 6 p.m. on that particular day. It was submitted that on a written complaint of Deputy Commissioner Mansa, an FIR was registered under Section 188 of IPC, that is for disobedience to order duly promulgated by public servant. After completing the investigation, the investigating officer had filed a challan against the petitioner. Further, the petitioner filed a plea for quashing of the FIR. While allowing this plea, Justice Anup Chitkara observed that there is an express bar of Section 195 of CRPC here. The section clearly states that court cannot take cognizance of the police report or challan under Section 188 of IPC unless there is written complaint by the public servant concerned for contempt of their lawful order. And complaint, which is defined under Section 2D, excludes the police report or challan. In another update, a Delhi court has allowed a 22-year-old electrical engineering student at Jamia Millia Islamia University, who is a UAPA accused, to write exams in Tihar jail, as per the examination schedule fixed by the varsity. The NIA arrested Mohammad Mohsin Ahmed from city's Batla House area last year. It was alleged that he was actively engaged in raising funds for the terrorist organization ISIS. The FIR was registered based on the information received by the Union Ministry of Home Affairs that certain entities were operating from various parts of the country for the furtherance of terrorist activities of ISIS. Ahmed is the only accused in the case. The NIA has alleged that Ahmed, on the directions of an online entity, was involved in raising funds for ISIS in India. Principal District and Sessions Judge Sanjay Garg of Patiala House Courts granted relief to him to write exams from the jail and directed the jail superintendent to ensure arrangements for facilitating the applicant to appear in the examination. And now let me tell you, CJI D.Y. Chandrachud today announced that Keshwanand Bharti judgment video commemorating the 50th anniversary of the landmark case is now available in 10 Indian languages on the Supreme Court's website. The CJI emphasized the importance of breaking down language barriers to make the work of court accessible to wider section of society. You already know that in April this year, on its 50th anniversary, the Supreme Court had released a video dedicated to the historic 1973 fundamental rights case. The video provides the viewers with details of the case background, key legal issues involved, the judges who presided over the bench, the advocates who appeared in the case, arguments made, and the conclusions reached. This initiative follows the Supreme Court's ongoing efforts to translate judgments into various Indian languages, with 20,000 judgments already uploaded on the electronic version of the Supreme Court reports. In a Supreme Court ruling, a case of apparent collusion and favoritism has come to light. The bench, comprising Justices Rajesh Bindal and Hema Kohli, was hearing an appeal against the division bench judgment of the Delhi High Court, which upheld an order of the Central Administrative Tribunal. The tribunal had dismissed appellant's claim for grant of same pay scale as had been granted to another employee because they were both governed by the same set of rules and discharging the same duties. The court criticized authorities for granting an unjustified higher pay scale to the employee, highlighting a violation of the established norms. It directed the recovery of excess amount paid to the employee, acknowledging deliberate nature of the infraction. This verdict exposes a concerning pattern of manipulation, and implications of this decision may have broader ramifications impacting similar cases in the future. The Gujarat High Court today issued showcase notices to Income Tax Department for allegedly raiding an advocate's premises and seizing certain digital and physical files and documents without a warrant. The court has directed the erring officers to come up with their explanation regarding the raid. In this case, the document being sought by the department was an MOU concerning 2 transactions which were held by the advocate in his professional capacity. Calling the approach of the IT department unexpected, a bench of Justice Bhargav D. Karya and Justice Niral Mehta sternly asked the counsel of the IT department to return the documents and make a public apology. Furthermore, the court also said that this kind of approach of the department to conduct search and raid would have a detrimental effect on the public, as everyone will be under fear and unable to perform their duty fearlessly. In a groundbreaking move towards gender inclusivity, the Patna High Court has taken a historic step by appointing an entire team of female judicial officers to key administrative positions in Bihar State Legal Services Authority. Let me tell you, over the course of its 100-year history, the High Court has only appointed 9 women judges, constituting less than 1% of the total judicial appointments. This dearth of representation extends to the realm of senior advocates, with only one designated female senior advocate currently serving in the Patna High Court. This collective appointment marks the first time in history of the Patna High Court that an entire office is being led and operated by female judicial officers. This is a landmark for the history of women representation in the Bihar judiciary. And lastly, a plea has been moved before the Kerala High Court seeking a direction to the Government of India and the Election Commission of India to prohibit 26 opposition political parties from using the acronym I.N.D.I.A as the name of their political alliance for upcoming 2024 parliamentary elections. The acronym stands for Indian National Developmental Inclusive Alliance. The petitioner submitted that the term was used as an attempt to create political hatred and to deceive and polarize the voters. The petitioner also argued that a similar plea was filed before the Delhi High Court, in which the Election Commission stated that it could not regulate political alliances under the Representation of People Act. That in a public litigation before the Apex Court, it had directed the petitioner therein to withdraw the petition and to approach the Election Commission of India. The petitioner said that he submitted a representation before the Government of India and the Election Commission, but no actions has been taken so far. Thus, the petitioner approached the High Court seeking a direction to the Election Commission of India and the Government of India to prevent use of the acronym. A division bench comprising Chief Justice A.J. Desai and Justice V.G. Arun adjourned the plea today for hearing at a later date. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month.